I note that this Friday afternoon is a very empty hall.
It is indeed, Chair.
We can just assure Mr. Mainganya that it's got nothing to do with him.
Indeed not, indeed not. I think it's a combination of Friday afternoon and lots of figures that we've been dealing with.
That's right.
Thank you, Chair. If we may proceed then, Chair, there were two aspects, there were three aspects that Mr. Manganya was going to follow up for us on over the break.
Yes.
The one related to the subcodes. I indicated to him that as his evidence progressed after that point, they no longer became material, certainly for my purposes.
Okay.
So I'm not concerned that we go to those subcodes.
Okay.
The other two I do want to just reference quickly, in fairness to Mr. Manganya, and then one or two follow-up questions, and then we'll proceed. Chair, for this purpose, we need to be working with DD 13B.
Yes, I've got it.
And if you pick that up at page 189, Chair, the question arose in the context of the issue around the tender with SAA being for 3 years, but then the loan assessment being done on a 5-year basis. And the question to Mr. Manganya was, well, how could that really have occurred? And he indicated that there had been an assessment as to what the extent of the exposure would be over at the end of the 3-year period. And I asked him to draw our attention to where that was in the submission. And that you'll find at page 189, as I have it. In the second paragraph there, this is part of the submission that went to the committee on the February 2017 date. Is that correct, Mr. Manganya?
Correct.
Thank you. And what the paragraph you've drawn to our attention is the second paragraph there. It reads, through the outcome of the due diligence, the team has assessed that the accountants used by EML for monthly reporting should be changed. This has been included as an undertaking. And then the relevant part begins in the next sentence. The IDC exposure to the senior loan outside the 3-year period of the SAA contract is 1.12. I assume that means million. Yes. And then it goes on and says, a mitigant is that there is 1.8 million cash in the bank at that point to repay the facility. Is that what you wanted to draw to my attention?
Yes.
Mr. Manganya, the 1.8 million that is reflected there is a product at the time of that error still being included in the cash flow statement, correct?
That's correct.
So the error would have to be taken into account to know what the actual cash in the bank position would be after the 3 years. Is that right?
That's correct.
And as I have it from your reconstructed model, that would reduce to about 1.1 million. Is that right?
That's correct.
Mr. Manganya, of course, you've traversed this with the chair already, but...
Yes, I'm sorry. I think I got lost. You went
Apology.
to 189.
189, the second paragraph there, Chair.
Oh, okay.
It's the last sentence of it.
I was seeing that 1.12 and that
Yes.
1.8, but I wasn't seeing some of the figures you were mentioning.
Apologies. So that second last sentence says there's going to be an exposure on the senior loan, that is the working capital loan, of 1.12 at the time. That's million. But the mitigant that's identified is that there's going to be about 1.8 million in cash in the bank, correct?
Correct.
What I've also understood your evidence to be is you recognize that because of the error that had been included in the cash flow statement at the time, that 1.8 million figure would have to be reduced, correct?
Correct.
And it would go down to about 1.8 million, is that right?
1.1 million.
Apology, from 1.8 to 1.1, correct?
That's correct.
So there's less available cash than is recorded here at the end of the 3-year period.
Correct.
If the error had not occurred, correct?
Correct.
Would that have influenced you materially if you'd been making this decision?
No, because the amount of cash available is more or less equal to the outstanding balance then, because there's 1.1 outstanding, and then there's a balance of cash of 1.1.
Right. And just to conclude this, Mr. Manganya, of course, that whole cash flow model depends on a range of assumptions made after the 3 years in which the contract which has been tendered for would apply. Is that correct?
That's correct.
So you, in a sense, if I can understand and make sure we're on the same page, when the IDC looks at its modeling, if the SAA contract had been awarded on the terms of the tender, it then has a realistic sense, assuming performance under the contract and on both sides, what's coming into the company for 3 years. Is that right?
That's right.
But after those 3 years, so this was in 2017, after 2020, everything else we see in those cash flow statements are projections, they're assumptions. Is that correct?
Yes, that's beyond the actual contract.
It is. And you traversed with the chair earlier, well, that's part of the risk, as I understand it, that the IDC evaluates, correct?
Yes, that's correct.
And what was the basis for those assumptions and the figures put into the cash position of the business thereafter?
So in the submission, the team indicates that it has grown the projections by the inflation rate beyond the contract, among other assumptions.
So would that mean that they assume, for the purposes of the model, that what has been secured in the tender with SAA for the 3 years is likely to continue plus inflation?
So they assumed in this one, like they indicate, that the submission would be for 5 years, and they also assumed that the client will get other contracts on termination of the SAA contract.
And contracts of a similar value, correct?
No, not really. Contracts from different other suppliers, not necessarily of a similar value.
But if you're, and correct me if I'm wrong, but if you're increasing off a base for inflation, you're assuming that base remains the same thereafter, which would assume a similar value of contract being obtained elsewhere, wouldn't it?
Or more, or less.
Indeed, but they
Yes.
put a figure in,
Yeah,
and as
yeah.
I understand the figure, assumes a continuation of the same cash receipt over time as was secured for the 3 years plus inflation.
Yes, so that they start at the base and put some growth assumptions on the company, and they indicate in the submissions which other prospect that the client was pursuing, and they model assumptions based on that. Yeah.
Thank you. The second aspect that I asked for you to look at over the break related to whether there was any reference to the justification for MSEP funding as being the value add that EML would bring. And you drew my attention in the same volume, Chair, to page 222.
Got it.
And Ms. Manganya, I had introduced that question on the basis that I had not seen a reference to value add as the justification for the MSEP approval or qualification in this submission. What you've drawn my attention to is right at the bottom of that page 222, where there is a reference to the approach that airport takes to people in the position like EML would have been in its contract with SAA. Is that correct? Okay. And what it records there is accessees throughputters. Chair, you'll remember that phrase of throughputter from the evidence of Mr. Vaughan. The real essence of it was that a company like EML was going to purchase the fuel from one of the oil majors, Total, etc., and then was going to utilize the pipeline at the relevant airport as a throughputter to then provide that fuel plus a margin that SAA would pay into the aircraft. Is that consistent with your understanding of throughputter status?
That's correct.
Thank you. So what is recorded here is AXA sees throughputters as a value add to the process, as they will be sourcing the fuel, purchasing the fuel, transporting the fuel, storing the fuel, and testing the fuel before it is put into the planes. You and I might have been at cross purposes insofar as I was interested in it being presented as the justification for the MSEP qualification in this submission. Do you know whether this is what Mr. Kobina took into account when he indicated to you, when you followed up with him about this topic, that there was a value add that EML was going to be contributing?
Yes, so in one of the correspondence, and also in the investigation that we'll talk about, he does draw reference to that. That was indicated in the submission.
Thank you. Do you hold the same view, that it's a value add as understood under the MSEP program when an entity purchases fuel from one of the oil majors and enters into arrangement to then put it into the aircraft thereafter? Is that the sort of value add that MSEP is interested in?
So I would understand that the client doesn't just simply take and put, he does something. So in the submission, there's a quantification of what that value add amounts to. But I do not know if it's sufficient to qualify for MSEP purposes.
If it was simply purchasing the fuel, transporting it, using the pipeline and putting it into the plane, is that the sort of thing that you think would qualify as a value add?
No, I wouldn't think that's value add.
Thank you. Sorry. Apologies. I've taken two files. If we can then go back in your affidavit, Mr. Manganya, and my hope is, Chair, that there are not too many topics to still deal with Mr. Manganya. So we look on good terms to complete this afternoon. I would like to pick it up at page 6, if we may, Mr. Manganya. That's in DD 13A. And it's under the heading on that page, in bold 4.4, request to replace the SAA contract with SA Express SOC Limited. Now, Ms. Anganya, for this point, I don't want to have you move back and forward between files unless it's necessary, because the document I'm going to refer to now is one we've looked at before, and I just need to quote from it. But if at any point you want to go and look at the document, feel free to tell me that. It was in the conditions precedent of the decision in February 2017 that a requirement that there be a signed agreement with SAA was stipulated. And I just want to read how it was framed in that condition precedent. It said a signed off-take agreement between EML Engineers and Construction and South African Airways with the terms to the IDC's satisfaction. Do you recall that?
I do.
So when this was approved, given everything we've traversed previously in your evidence, as I understand it, at that point the tender hadn't been awarded, correct?
Correct.
So as I understood your evidence, it was a protection for the IDC to say, well, it's a condition precedent of all of these agreements, both loans and the guarantee facility, that there must be a signed agreement between EML and SAA with terms to the IDC's satisfaction, correct?
Correct.
Right. Then, as I understand your affidavit, that does not materialize, that contract. Is that right?
That's correct.
So then what happens?
So around the 26th of July, the Basics and Chemicals team requested an amendment to the approval of the conditions set by the Special Credit Committee. Amendments that are requested by transaction teams are presented in the form of a memorandum addressed to the Post-Investment Committee, which is comprised of the divisional executive directly responsible for the transaction, the divisional executive responsible for transaction support and post-investment management, the chief risk officer, and the general counsel. The Post-Investment Committee, abbreviated PIC, does not usually sit as a committee and does not have a chairperson, as each member considers the requested amendment independently and indicates his or her approval or objection.
If we could just stop there, Mr. Manganya, you indicated that earlier in your evidence today, that you don't convene as a committee and that it's done on a almost round-robin basis. And I said to you in that evidence, when it became relevant, I'd ask you in relation to this decision, where the submission was made on the 26th of July 2017, whether you recall how soon after that submission was received, the decision was taken.
I don't recall exactly.
Would it have been a matter of days in all likelihood?
So some members could have been approved it on the same day, some a day or two later.
Indeed, but we're not talking about more than a week or so. Is that fair?
No.
Thank you. In other words, yes, you agree.
Yes, I agree.
It's just the record doesn't always reflect the manner in which you've indicated the answer. Thank you. So shortly after the 26th of July 2017, a decision was made, and what decision was that?
So the decision was to agree to the requested amendment that instead of the SAA contract, the SAA-X contract would be used as the off-taker. That's
Okay, thank you. So now we have a substitution of funding that was premised on an SAA contract being replaced by an SA Express contract, correct?
Correct.
I'd like to go to that actual submission because there are aspects of it that we do just need to traverse. You'll find that in DD 13C, and it commences at page 631. Mr. Manganya, you'll be in file C.
Okay.
At page 631. Thank you. Can you confirm what document that is at page 631?
So it's a memo addressed to the Post-Investment Committee. It's from the Basics and Specialty Chemicals Business Unit. Its reference is for EML Engineering and Construction.
Thank you. And is this a submission that you've been discussing that went to the Post-Investment Committee to change the funding from an SAA contract to an SA Express contract?
Yes. Correct.
Thank you. And then if you just go to page 634, it's a few pages on. Under the last table on that page where there's capital letters approved ahead of it, I see there in the third line the Chief Risk Officer identified. Is that you?
That's correct.
And so that's your signature?
That's correct.
So you were part of the group that approved this change from the SAA contract to the SA Express contract. Is that right?
That's correct.
And this occurred just a few days after the 26th of July 2017, correct?
Correct.
I'd like to look at the actual wording that was used in this request to the committee, of which you were a member, and you'll find that at page 633. You'll see there that the request under 1, if you could read that for us, what is the first request that the business unit makes to your committee?
It is requested that the IDC consent to change in CP to allow EML to draw funding based on the SAX award letter.
And then under 2?
It is requested that the first drawdown be changed from 6 August 2017 to 30 September 2017.
So that was to push the drawdown date out slightly, is that right?
That's correct.
Okay, I'd like to focus a bit on point 1 though, because you'll correct me if I'm wrong, but this is a request as I read it, that there be a consent to change the condition precedent, that's the condition precedent that we saw previously, related to the need for a signed agreement between SAA and EML on terms satisfactory to the IDC. 2, a term which now stipulates that EML will be allowed to draw funding based on the SA Express award letter. Do you regard an award letter as being different to a contract?
Yes, it is.
So why would the request be being made to allow funding purely on the basis of an award letter in circumstances where previously it had been of some importance, as I understood your evidence, to the IDC that they actually had a signed contract in place?
No, so this memo is requesting the change from SAA to SA Express. And in support for that, it is indicating that here's an award letter from SA Express. So I think if we go to page 632.
That's the page back, yes.
That's a page back. So I think that paragraph after item 3, so which says, as part of the approval process, condition precedent 6.1.7 of the guarantee facility was for EML to obtain a signed offtake agreement from SAA Limited. So it is that condition that is requested being changed.
Correct.
So it remains a CP, but instead of the contract being SAA, the contract becomes SAA Express. So if you read item number 4, it doesn't mean that on award payment will happen, because the CP will now read we must get an offtake from SA Express. It's not saying based on this letter we can pay. It's saying based on this letter can we change the condition.
Is that how you understood this document at the time?
Yes, that's how I understood it.
Because can I say to you, that language isn't readily apparent to me, certainly, as an outside reader of this. And the reason is because when this document talks about the change, it talks about a change and only ever makes reference to an award letter that has been received from South African Express.
Okay.
Do you accept that just in terms of the words used?
Yes. No, I can understand, but in support of what I'm saying, it is factual that upon this change being made, the client started requesting payment. And our teams and legal teams said, no, we can't pay you. We still need the contract first. So that is my understanding. It is just changing the condition. Disbursements could not happen on the basis of this letter.
And do you understand the position to be that at 27, or call it 29 July, when the approval was given, the IDC had not yet seen the agreement?
Yes, at that point, and it is not there, the agreement.
There's only the award letter,
only the
is that
award
right?
letter. That's right.
And let's just go to that award letter because it's a few pages on. It's at 635.
Yes.
Is that the award letter that you refer to?
Yes, this is the one that was attached to this memo. Okay.
And I understand your evidence to be this, you understand, is not a contract, but, and you also, your evidence is that as at this date, the IDC had not seen a contract, correct?
Correct.
But thereafter it was obtained, is that correct?
Correct.
And disbursements were made only after it was obtained, correct?
Correct.
Were its terms interrogated at all by the team in the IDC?
Yes, I spoke to the legal team. They indicated that they did review the contract.
Did they engage with South African Express at all about it, like they'd engaged with SAA previously?
No, they didn't.
Because as I understand it from Mr. Rama's affidavit, and correct me if I'm wrong, there's no second due diligence that's done when a change of this nature occurs. Is that right?
Yes, there's no second diligence in the sense of restarting the process. But they still requested to do diligence on the terms that have changed.
Right. If we're at 635, the one thing I just want to probe with you there is if a due diligence is not done when a change of this nature takes place, I assume interrogating the prescribed litres of fuel that were going to be procured from EML would not have been interrogated at all, would it?
So with regard to that, the team indicated in the submission that based on these liters, then they redid the financial models that we've been discussing and then re-verified the supporting prices to those liters to test if the client would be able to make sustainable income from this new contract. So that is the extent of the interrogation that they did in checking that what the client bidded was supported by reasonable prices from the suppliers, and then they used those liters to do a new model. And based on that, they indicated in the memo that based on the new model, the client would still be able to afford the facilities that were granted.
And in fairness, Mr. Manganya, to the IDC, I expect in this process, you're not on the lookout for fraudulent contracts being concluded with state-owned entities, are you?
It is a risk that is always there in the current environment. So hence, the legal scrutiny must do reasonable processes.
Indeed.
To satisfy itself that the contract that is presented to them is valid, and that's a line between doing a forensic process on the contract versus doing reasonable measures to check what you're getting could be from a reliable institution.
Indeed.
So we have to think about the risk of fraud when we do that.
The reason I raise it, Mr. Manganya, and this is not evidence, I assume, of which the IDC was aware at the time, but the 8 million litres that were going to be provided according to this letter of award to Pilanesberg Airport, the Commission has received evidence was wildly in excess of the number of litres that airport would ever need annually. But I assume that was not known to the IDC at the time.
No, I didn't know it.
And the process of review that was undertaken did not reveal that.
No, it didn't.
Thank you. And then if we could go, Mr. Manganya, back into your affidavit. And we will pick it up at page 8, if we can. At page 8, the heading begins 4.5, drawdowns paid directly to EML. Do you see that?
Yes, I do.
Mr. Manganya, I know at the time you may not have been aware of a particular invoice for a consultant that was included when the drawdowns were sought by EML from the IDC. But you have seen Mr. Rama's affidavit before, have you not?
I have.
Can you assist us with what that particular invoice in the order of 1.5 million that was submitted to the IDC in respect of the drawdown related to?
That invoice related to a fee for consulting services that was invoiced by an entity called Memela Property Trust to EML.
And what were the services that were alleged to have been performed for that invoice?
So it was alleged that Memela Property Trust had assisted the client in compiling its business plan and getting funding from the IDC.
Let's go to that invoice if we may. You'll find it in DD 13B. And it's at page 456.
Yes,
Is this the invoice that we were speaking about?
correct.
And who is it from and to?
It is addressed to EML Engineers and Construction. It's from Memela Property Trust.
And the date of the invoice, what is that?
3 July 2017.
And the contact person on the invoice?
It's Eddie Komani.
That name came up earlier today, didn't it?
Yes, it's correct. He's the one who referred the business plan to Mr. Billy Kobina.
That was back in the middle of 2016, is that right?
That's correct.
So his name appears here again on an invoice. And what was the work for which this invoice of 1.5 million rand was raised?
It says scope of work, facilitation or raising of funding from the Industrial Development Corporation of South Africa.
So what is your understanding of this invoice being forwarded to the IDC as justification for a drawdown on its facilities?
So this invoice never featured in any of the funding requests that were made by the client. So it became apparent to the IDC only at the time when the client was requesting disbursements from the IDC. At that point in time, when a client requests disbursements, we request that they include supporting documentation as to what the money will be spent on. As we'll see in Mr. Rama's testimony, he indicates that at that time, among the invoices submitted by the client was this invoice. At which point, he says he indicated to the client that this will not be paid from the IDC because at no point in time was the IDC made aware that there is this services, and the IDC did not budget for this service. Therefore, he indicated to the client that this invoice must not be paid by the IDC. So then the client submitted invoices excluding this one, which is for equipment and working capital.
So this invoice, was it, well, I see that it seems to be addressed to EML, but I hear you talk as if it was directed at ITC, or did I misunderstand something?
Okay, so the client...
It was sent to EML,
Yes,
and
yes.
EML sent it to ITC.
Yes, that's correct. Because...
as part of expenses?
Yes.
Oh,
Okay.
but how could that happen?
So for approved expenses, it's normal. Remember, Chairperson, so we gave the client 6.5 million, And on that, he says, I'm going to buy this equipment, I'm going to buy this vehicle, I'm going to pay these salaries. So before we pay, the client must give us those invoices that he's received from the sellers of those equipment, so we can justify giving him money. So we're saying in that pack of invoices, he included this one, but then we said this thing is not part of what we know to be your funding
This
requirement.
is not equipment or anything like
Exactly,
that.
exactly. So it shall not be paid from the money from the IDC, because at no point did you tell us that there's a consultant that's helping you to do the business plan.
But why did you even go there? Why do you even have to say you didn't tell us? I mean, that if there was such an arrangement, it was between the two of them, isn't it?
Yes, Chair, but as per Vimal, he had to make it clear to the client that none of our money should be utilized to pay for this client, for this invoice. So,
No, I understand that completely. I don't know about Ms. Hoffman, but on the assumption that EML had asked Memela Properties Trust, they are raising funds, Properties Trust to facilitate or raise funds for them. That must be their own business.
correct.
How could they even begin to think they can pass that on to you? That's my reaction, you know. And I'm kind of thinking maybe IDC should have been much harsher.
I understand.
Maybe I missed something.
Your problem. So we will see later.
Yes.
Because later we discover that despite us saying don't pay this, the client went on to proceed to pay this invoice.
From the money obtained from.
Yes. So then he then shows us a contract between him and Memela Property Trust. And then in that contract, it says Memela had indicated that part of the funding request would include the services that he rendered. So it is the reason that EML was sending this invoice. He says Memela had indicated that it will be part of the funding requirements, which is a point we were saying, no, it's not. We are not going to pay it.
Of me, I think I would have been very harsh.
Indeed,
Yeah.
indeed, Chair. With respect, I share that sentiment. Do you think it was sufficient for Mr. Rama simply to say we're not paying it because it wasn't in the original terms? Or might he appropriately have said we're not paying it because the IDC doesn't pay 1.5 million rand only to be used to facilitate the very funding that the IDC is making available?
No, I think you should have gone further, Chair. You should have even elevated this matter to the IDC.
Indeed, Mr. Manganya, because as we'll discover, if this had been flagged at an appropriate time as being a basis on which EML was seeking drawdowns on the facility, possibly more about the arrangement might have been uncovered. Is that not so?
That's correct. That's correct.
Thank you. But as I have the evidence, all that happens is Mr. Rama goes back and says, we're not paying it, right?
That's correct.
You may not use the funding for this purpose. Is that correct?
That's correct.
And then what happens?
Or maybe before that, I take it that it's obvious that there had been no facilitation that was lawful that would have happened.
Yes, Chair. Up to this point in time, all the approval committees have never been made aware that there is a facilitation.
Okay.
And is it IDC policy not to fund where there is a facilitation?
Exactly, we will never pay that, Chair.
Thank you. I was moving on to what happened because you began in one of your answers to the chair recently to talk about when it was picked up that despite the indication that it should not be paid, it was paid. Can you explain to us how that came about? The uncovery of the payment.
Okay, so in terms of our processes, after we've paid the client the money, then after some period, once he's bought the items he needed, we go and do a verification that indeed.
You do a verification?
Yes, we go
Okay.
to the client now and say, where is the equipment that you bought and everything. So it is at that point that we discover that he actually utilized some of the money that we had indicated to pay this invoice.
And what further inquiries were made in that regard? You mentioned an agreement that was sought.
Yes. So then at that point in time, because the team had changed that did the initial application, so Mr. Rama was no longer part of the team. A new team went in, and as they do the audit, they discover that this payment has been made. And then they take the client on as to, why did you pay this? Because in our budgets, we don't see an expense item like this. Then the client says, I had to pay this because I had entered into an agreement with this Memela Property Trust that would help me to compile my business plan. And the client now indicates that because Memela is aware that the funds have been paid, therefore it demanded its payment. And the client says, in an email addressed to the team, it says it felt it had to pay this invoice. It is then that the matter was reported back to the IDC, because until that audit, we didn't know that the client had utilized some of our money to pay for this.
And whenabouts was that reported back?
So we became aware of this around 4 May 2018 as the credit committee.
And that is a date on which an application was made for further funding, is that right?
Yes, that's a date when application is made for further funding.
So at this point, 12.5 million has been extended to EML, and that was drawn down in August of 2017, as I recall it. Is that correct?
That's correct.
And then in May of 2018, early May of 2018, there's a further application by EML for about 8.5 million rand of funding. Is that right, Mr. Manganya?
That's correct.
And was this issue of the payment of 1.1 million made known to the committee that was asked to approve that further funding?
Yes. Now, on 4 May, it is at this point that the credit committee becomes aware, because now the team must submit the new funding request from the client, and they must also explain how the other money was utilized. So on 4 May, they report back to the team why the client needs more money now. Among other things, the contract had not started yet, and the client had bought the equipment in anticipation of this, and the client had paid salaries, and now it was running out of working capital. And we said, no, but how did you use the money that we gave you? And then it is at that point that the team reports back that, among other things that were paid, were for this business plan. So at this stage, if I recall, it was reported to the committee that an amount had been paid for helping the client to do the business plan. So at the committee, it was not reported in this manner as a facilitation. It was reported as a legitimate expense incurred to assist the client. But then we said we didn't budget for this. So Chairperson, sometimes our clients do use people to help them compile the business plan. But our condition is that it must be made known to the IDC, the scope of services to be provided. So the credit committee took issue with this matter, that, okay, provided the client helped you with the business plan, but you should have alerted the IDC that there's this service provider as well, and would have needed to assess if it's legitimate, because the team indicated that in all their processes up to this point in time, they had not seen any consultant. They've been doing their work. So when this was tabled to the credit committee, we didn't approve it at that point because we were not happy with this. We sent the team back to obtain further clarifications from the client as to how it's going to remedy this. And at that point in time, there were other breaches that the client had done on the facilities. So the credit committee did not approve the application at that point in time, pending resolution of those issues.
Ms. Mankani, I understood that the credit committee did approve the request for the 8.5 million additional funding initially. Was I wrong?
He initially declined it, and then they sent them back, and then they came back on the 18th of May.
And on the 18th, it was approved?
Yeah, so on the 18th of May, the issues that were raised by the committee were tabled, and the client indicated how it addressed them. Now, the IDC is at a point now where it had dispersed these facilities, the 12.5 million, and the client indicates that the contract from SA Express hasn't yet materialized, and then in the meantime it had bought the equipment and it had obtained the compliances that it required that were budgeted for. But now it had run out of funds. And then the client indicated that it had received 2 new contracts. One was from an entity called Fly Africa, and one was from GAL, the airport in Polokwane. And then it requested funds to service those contracts. Then the committee requested to know the client, how is it going to pay back this money that it had paid for facilitation fee. And at that point, the client, before that, a letter of breach was sent to the client, indicating our displeasure with what had happened with the facilities and requested how it's going to remedy that situation. And the team indicated in their responses that the client indicated that the funds would be reimbursed from the proceeds of a grant. I think it was expecting from the other suppliers. And then we put a condition as a committee, because it's not the 1.5 that was paid. I think 1.1 million was paid. So the committee indicated to the client at that point in time that it may not pay any further monies for any services related to this point in time. And then it is then on the strength of those contracts that were provided to the IDC and in view of the equipment that had already been spent on the facilities that the committee approved that application.
If I could just unpack a few aspects of that. What precisely did the client convey to the IDC as the reason for the fact that the SA Express contract had not been implemented?
I do not recall what it said. I think, among other things, it indicated that IDC released the guarantees late as a reason to justify, and then it couldn't provide the guarantees to the oil companies. Therefore, it couldn't order fuel. That is what was indicated in the submission.
Would it have been prudent to possibly engage SA Express at that stage to understand from them why the contract hadn't been implemented?
I think so, among other things, that should have been done.
You see, Ms. Mangani, if that had been done, the Commission has received evidence already that the irregularity of that contract that had been awarded to South African Express, by South African Express to EML, had already been picked up in South African Express in October of 2017. And an investigation had in fact been initiated as early as that. We're now in May of 2018 when further funding is being requested from the IDC. And the only explanation that the IDC, as I understand your evidence, was given by the client for non-implementation of that contract related to some delay in guarantees. Is that right?
Yes, but that is right. And then you must recall this funding that was approved was suspended.
Yes, indeed. It was suspended a few days later when a media article
in May.
broke.
So when we became aware of that, we suspended it immediately.
No, indeed. All that I'm interrogating now is when EML comes to the IDC for more money in May of 2018, a few things have happened between the 12.5 million that it received in August of 2017 and its application for more money in May of 2018. I'd like to list those for you. A facilitation fee, it had done so, correct? If you can just say yes for the record.
Yes, correct.
Thank you. It had, and that facilitation was a facilitation of the very funding that it had secured from the IDC, correct?
Correct.
And I understood your evidence to be previously that is irregular in the view of the IDC's processes, correct?
Correct.
It had then never yet implemented the substitute contract which the 12.5 million had been provided to it, correct?
Correct.
And notwithstanding that, as I understand your evidence, the IDC did not take further steps to try and get to the bottom of why that implementation had not taken place. Is that correct?
So the steps that were taken was the breach that was communicated to the client in terms of indicating that the IDC at that point in time may call the facilities if those breaches are not remedied. And then, so at that point in time, these issues that you are raising were raised in our risk report that we did. As you would see in my affidavit, the fact that so I'm on page 10.
Thank you.
So on page 10, in our assessment of the situation, we did indicate that the client had failed to meet the condition regarding the offtake contract. There was no offtake contract from Fly Africa. The SA Express contract that you indicated had not materialized and been implemented at that point in time. So these matters that you are raising were debated at the committee. Now the question was, what do we then do with the facilities that have already been approved by the client? Now, at that point in time, two things could happen, Chairperson. So, one, we can call the facilities, take the security, and close the business. Or two, we can review the clients, what it says it's going to do to remedy these breaches that have arisen. And three, we consider the facilities that we have dispersed. Are they collateralized? Are they supported by hardcore assets? So those are the two issues that often arise when clients don't respect our agreements. We reach a point where we have to close down the business. So the committee was confronted with that decision. Does it close down the business and sell the equipment, or does it request a remedial plan? And based on the remedial plan that the client had indicated, being indication that it had obtained further contracts, being indication that it had obtained additional financial support, I think from Total or Engine, one of the other guys. And then it indicated that it had obtained the JIG accreditation, which we paid over $1 million to get that accreditation by other international operators, so it can be able to supply fuel. And whether we close down, and the fact that at that point in time the client was employing about 5 people, and the decision of closing down would be those jobs lost. So those are the issues that the committee had to contend with versus these breaches from the client. And given those two indications, the committee decided to support the client further to avoid closure of the business.
Mr. Mangania, was the fact of the facilitation fee not on its own enough of a red flag to make the IDC cautious about further extending funds to EML?
So Chairperson, to my collection, this fact that this facilitation fee only came to the IDC when we did the investigation to the people. But when
Mr. Mangania, if I could just come in there, because I understood your evidence to be previously that it was brought to your attention specifically, the agreement between Mamela Trust and EML was called for, and you actually made it a condition of the further extension of the loan that there be some arrangement with EML about the fact that it was going to reimburse the 1.1 million. Did I understand that incorrectly?
No, you're not incorrect. I'm saying when it was reported to the credit committee, it was not reported in this fashion that it was a facilitation. They said the client had paid a consultant who helped them to do the business plan. At that point in time, the committee had not seen this invoice. The matter was reported to the credit committee.
I see. So you hadn't at the time seen either the invoice or the commission agreement?
Yes, at the it was not presented there.
Thank you.
Well, this 1.5, did you ask EML exactly what it is that was done by Mamela Property Trust, the Properties Trust, that Mamela Properties Trust understood to constitute facilitation or raising of funding from the IDC?
Yes, Chairperson. When we investigated this, the client sent a long email to the IDC. It's just that I don't have it now, which indicated to the IDC what services this Mamela Property Trust is alleged to have performed.
But what was it really? Was it preparation of the submission? What was it?
You'd recall, Chairperson, in the beginning, we advocate referred to a business.
You may have, but I
No,
remember
I
I told you I have I've given up trying to hear what you say because I hear some things, I don't hear others, but I've given up. I think it's the nature of your voice.
Okay, Chairperson.
Yeah, so what is it? Was it preparation of the submission or what was it?
Yes, I was
In essence.
I was saying that business plan that the advocate referred to earlier in the beginning, it was among other things that are alleged to have been done by this Memela Property Trust in return for this fee.
But is that understood to be the raising of funds? Generally speaking, when somebody raises funds, can anybody raise funds the way it's understood in business, or do any facilitation without talking to the person who is being asked to provide funds?
So, Chairperson, I think perhaps as the advocate proceeds, it will become clearer what happened.
I'm ahead of. Okay, all right.
Because we were asking the same question in the credit committee. What has exactly this person done to deserve this?
Yes. Well, the reason why I was asking, I was going to ask it much earlier, but the reason why I asked it now was because Ms. Hofmeyer talked about whether it wasn't a sufficient red flag to IDC. So it brought back that question in my mind to say, but if you as IDC know that there is nobody who has been talking to you on behalf of this client to try and raise funds, if you are shown an invoice that says somebody is demanding money because they facilitated or raised funds with you, not with somebody else, and you know that there's no such, shouldn't that have said to IDC, hang on, maybe there is fraud here?
So, indeed, Chairperson, the credit committee that initially rejected this application was very displeased with this, and it is especially for that reason that it said a letter of breach must be issued to the client, and it's for that reason that they sent the team back to the client to obtain explanations as to exactly what happened. So I fully agree with you. We were not happy with what has happened here, Chairperson.
Okay.
Mr. Manganya, I appreciate everything you've said about the steps that were initially taken, the breach letter sent, the feedback that you obtained. But the fact of the matter is the IDC did decide to extend another 8.5 million to EML, did it not?
It did.
It did. And back to the chair's question, isn't just the mere fact that there's a facilitation fee of now 1.1 million, which is not an insignificant amount, is it, Mr. Manganya?
It is.
It's significant, isn't it? I mean, especially if it's for preparing the business plan that we looked at previously, that is a business we should all be getting into, because as I see that business plan, it's about 10 pages long. It's not particularly difficult to put together. Why was this not more of a concern to the IDC when it agrees to provide 8.5 million rand more funding?
It was a concern, Advocate. Also, what was a concern was the money that we had already incurred on the client. We had to recover that money.
And as I understand your evidence, you made a brief reference to a media article. What happened with the media article, and how did that influence the IDC's processes? If you'd like a reference for that, it's at page 9 of your affidavit, and it's at paragraph B on that page, where you refer to media reports on the 27th of May, 2018.
Okay. So, the relevant, it says, however, on 27 May, remember this facility was approved in 18 May. So on 27 May, various negative allegations were published in the media regarding EML. Upon this media allegations being brought to IDC's attention and my attention, I immediately communicated to the head of the Basic and Chemical Special Unit that no drawdowns should be allowed on these facilities until all the allegations referred to in the media above have been resolved. And then I have attached proof of that correspondence. So in a sense, what happened, immediately after we approved, we read about these fraud allegations concerning our client. Then I told the business unit that they shouldn't allow any disbursements until we understand the nature of these allegations. We then engaged SA Express to say, we have funded this client, we read about these things in the media, can you tell us what is happening? Because we will not disperse on these facilities. So at that point in time, SA Express indicated to us that they are investigating. They've launched an investigation. And then there were several to's and fro's between us and SA Express regarding this allegation. But to ultimately, we never got to disperse these facilities because we were telling the client that until we get a clearance on the allegations, we will not disperse. And that's where we are. We never got to disperse on these facilities up to this point in time.
Ms. Manganya, just a few follow-up questions there. Who did the IDC engage with at SA Express?
I do not remember, but I was forwarded with the email correspondence. I think at some point in time, it went all the way to the CEO of SA Express.
I have not seen that correspondence to the best of my recollection, so maybe you can provide that to the Commission.
Yes, we
but
did provide it.
What I'm interested in is whether, in your testimony you said that you were told they were going to launch an investigation. Is that what they said?
Yes, they said we cannot tell you anything because this matter is currently under investigation.
Currently under. Did that
Yes.
suggest it was already being investigated, or pursuant to the media reports it was going to be investigated?
I think it gave me the impression that there was an investigation underway. I don't know if it was started because of the media or it was already proceeding.
Well, it will be useful to have that correspondence, because we know from the evidence of Ms. Look that she raised this for investigation as early as October 2017 within South African Express. And if you are engaging them in May of 2018, that investigation should have been well underway, if not completed by then. So it would be of interest to the Commission to see that correspondence, if we can.
Okay.
Right. The next thing I just want to ask as a follow-up, is it fair, Mr. Manganya, to say that but for the media reporting on this issue, those drawdowns would have occurred?
No, those drawdowns were dependent on contracts being provided to IDC.
Which contracts were those?
The Fly Africa contract.
So that would be another prerequisite.
Yes.
But the fraud that had taken place and the irregular procurement in SA Express was the subject matter of this article, is that right?
Yes.
So it could have been the case that EML had secured other contracts, pursuant to which funding would have flown, but this issue around SA Express would not have been unearthed. Is that correct?
Yes, this chairperson did help us because at that point in time, we had not dispersed any facility. So these allegations, when they became apparent to us, we realized that we cannot proceed. Hence, we stopped the facilities. So they were crucial in us stopping this decision because I was not aware at that point in time that there is an investigation currently happening in SA Express.
And just to be clear, what was not made available was the second request for funding, which was the 8.5 million. But by this stage in May 2018, there'd already been 12.5 million released. Is that right?
Yes, for the purchase of the equipment.
Well, and the working capital
Yes,
loan.
that's correct. That's correct.
What has happened in relation to that? Has there been repayment on that loan?
So Chairperson, because we refused to release funds on this facility, the client couldn't supply any other funders, and then it fall in breach with our facilities. What has happened is we have had to perfect our security. We have had to go to the court, and we've perfected our collateral. And so our security that we funded, being the vehicles and everything, we took it under an order of the court.
So just so I have it clear, there was never any repayment of the loan made by EML, is that
Yes,
correct?
That's correct.
Then if we can move to page 11, Mr. Manganya, because this is where the further investigations of the Commission...
I'm sorry, Ms. Hoffman. Did you say that there was some security that you called or called
Yes.
back or whatever? Huh?
Yes, Chairperson.
And in what form was that? Where was the security?
Chairperson, when the client came to us,
Yes.
it requested money to purchase
Equipment. Yes.
which included Bowsers, tanks. So these are motor vehicles,
Yeah.
and that is the security which we took as part of our facilities. We registered a special notarial bond over those assets. So meaning we would look to either realize them to recover the money that we spent.
But you are still going to do that. You haven't realized the money.
Yes, Chairperson, we have not realized it at this stage.
Yes.
We are holding the security because we have to find the best way to realize it such that the institution does not suffer a loss. So which may include offers from prospective companies who use that equipment, or it may include other operators who are able to use that facilities which we have improved. So we have not disposed of the equipment at this point in time because the perfection of the court, I think, was granted. I don't recall the date. We had to go through the court process.
Or you had to wait for the litigation.
Yes, we had to go through the court processes
Yeah,
to register
yeah.
that bond. Yes.
But in the meantime, when you talk about vehicles, if you talk about a year later, they are depreciating and all of that, isn't it? I'm not suggesting that there might be a better way in which you could have done. I'm just stating what would be a fact if they are just sitting, if they are parked somewhere for a year, because I guess in the nature of your job, you don't use them, you have to sell them. If they are parked somewhere for a year, they are depreciating.
Yes, Chairperson, what you are saying is correct, and that is what happened in these instances. If we decide to foreclose, it comes at a huge risk to us. That's why we really have to balance that decision. When the client can't afford to pay our facilities, we have to think which is the best way to protect what we have spent. Because if we take them back, we risk selling them at a far discounted price. Now we have to look, is there another operator who is in this business who can use these facilities? Therefore, sometimes we invite prospective bidders, so we sell the business as a going concern, so that we don't suffer as much loss as we would have suffered if we just dispose them individually in pieces. But the court processes do add another risk to that, because we can't do anything until we get legal right to those assets.
Well, I don't know if you are able to say this, if you can't, then you can't. I get the impression that you are unlikely to get to recover much through them if you bear in mind exactly what you had given this client.
So it is possible, Chairperson, but
there are challenges.
I did inquire from the team that is handling this, what is happening, and they indicated at that stage that there was a prospective offer on the business that is close to what our facilities are. But I cannot say anything about that. I have interrogated the offer, but you are correct. The risk that we may suffer is there.
Mr. Mangani, in your experience, does foreclosure usually involve loss?
Yes.
Mr. Mangani, if we then move to page 11, this is where you pick up a topic there, 4.7 in bold, entitled Billy Kobina. Before we go through this, because this is really the concluding aspect of the evidence, Chair, prior to your meetings with the Commission's investigators on this topic, were you aware at all that there may have been irregular conduct on the side of the IDC in relation to this funding transaction?
I was not aware.
And can you then take us through what was disclosed to you in your engagements with the Commission, and then what further steps have been taken by the IDC in that regard?
Okay. So in our engagements with the Commission, it was put to me whether I'm aware that Mr. Billy Kobina is a trustee of this entity called Memela Property Trust. I then indicated that I'm not aware, and then, but I will go back and investigate. So when we went back to the office, we instructed a forensic investigation into this whole aspect of this transaction upon becoming aware that Mr. Billy Kobina is a trustee of this entity which had invoiced us. Do you want me to proceed? So
Indeed.
Then the investigation was concluded, and indeed it was confirmed that Mr. Billy Kobina is a trustee, and it was also confirmed that he had not declared this to the IDC. We have a policy that all employees must declare their conflict of interest. We have a conflict of interest register. So he did not declare in any manner in that register that he was a trustee of this thing. And then furthermore, during the investigation, Mr. Kobina confirmed that he received money from Mr. Edward Komani.
What was the amount of the money that he indicated he'd received?
It was 50,000.
50,000 rand.
Yes.
And how did he receive it?
He said, I think it was paid in cash.
Mr. Manganya, was the interaction between the IDC and Mr. Kobina when this confession was made recorded?
I understand it was, Chairperson.
Thank you. Certainly when we met previously, we did request that we have that recording made available to us. Could you assist us with that? We haven't yet received it.
Okay, we will, Chairperson.
But as I understand it, there's a forensic investigation, and in the course of that, there is an engagement between the IDC and Mr. Kobina. Is that correct?
That's correct.
You indicate now it was recorded, and you'll make that recording available to us, correct?
Correct.
And in that interaction, Mr. Kobina admits to having received 50,000 rand in cash from Mr. Edward Komani. Is that correct?
That's correct.
What then followed in relation to Mr. Kobina?
In relation to Mr. Kobina, we instituted a disciplinary hearing, and then on conclusion, he was found guilty of the charges that were put to him, being failure to declare and a breach of our code of conduct in accepting this payment. He was found guilty, and it was recommended that he be dismissed, and he has been dismissed, and then we reported this matter to the police as well. We opened a case against him.
I understand from your supplementary affidavit that Mr. Kobina also indicated to you further information in relation to Mr. Rama's involvement in the funding transaction. Can you explain to us what Mr. Kobina relayed to you?
So he also indicated that he made a similar offer, him, Mr. Kobina, to Mr. Rama, that he will also be given 50,000 if he assists in getting these transactions approved.
And did you take that further with Mr. Rama?
Yes, he was included as part of the investigation for failure, first to ascertain the fact, whether it is correct. He did also admit that it's correct that an offer of this if an amount was made to him. He does not indicate what the amount was, but he confirmed that this was made. And then that was also not reported to the IDC. So we also instituted disciplinary hearings against Mr. Rama. And we started the hearings, and then before we could conclude, Mr. Rama resigned from the IDC. So that disciplinary hearing couldn't be concluded, but also a case against him was reported with the SA Police.
Thank you. Mr. Manganya, insofar as the evidence that you've presented here today is concerned, there's certain just conclusory aspects that I'd like to get your comment on, if I may. And it's really in an effort to try and draw together what evidence we've heard from you today. The first is that, do you agree that pursuant to being made aware of the information related to Mr. Kobina in particular by the Commission, the IDC has established that corruption did take place in this funding transaction?
Correct.
And I also would like to suggest to you that in the course of the evidence, it has become clear that certain aspects of the IDC's process in deciding to fund EML Energy was inadequate, and I'd like to give you the respects in which I suggest they were inadequate for your comment. The first is that this application should never have been pre-approved for MSEP funding. Do you agree with that?
Can I comment on that one?
Indeed.
So Chairperson, on that one, the confirmation from DTI that this is not included came post-approval of the transaction a year later. What the team indicated is that in their motivation, they anticipated that there would be blending and value add. And as part of our of our processes to approve these transactions, we do invite the MSEP people to sit in our credit committee. So at the point when we approved this transaction, they were also part of the credit committee. So the committee didn't take that decision lightly. It was together with the people who are responsible for MSEP. And at that point in time, it was not clear that this particular industry doesn't qualify for MSEP. So it was made clearer by DTI a year later. So I agree now that we know, but at that time we didn't know that it doesn't qualify for MSEP.
Ms. Mangani, if I can just follow that up, it was a false representation to that committee that EML was involved in blending at all, wasn't it?
Yes, EML was not in blending as far as it was indicated. So what the team motivated, as I understand it, because I was not in that meeting, that was anticipated to happen later, but at that time it was not in blending at all.
Well, as I have your affidavit, when Mr. Kobina was pressed on this with you, he didn't use language about anticipation. He said he qualified them as pre-approved for MSEP because EML was involved in blending and value add. Did I recall your affidavit incorrectly?
No, I think he said there was going to be blending. Yes.
I didn't read your affidavit in that way. But you accept now that it should not have qualified, is that correct?
That's correct.
And you accept that it was falsely represented at the time that they were involved in blending, if that had been the representation?
Chairperson.
Isn't that the same that the two of you have just talked about?
Indeed.
Where he says he understands that they said it was going to happen.
Indeed.
Yes, Chairperson. So I'm trying to say I do not know if the team intentionally mailed a false representation or whether they understood that it would qualify then. So that is what I'm trying to say. I do not know if they intentionally made a false representation or they understood it to be value adding at that point in time.
Was that an aspect that was traversed with Mr. Kobina in his disciplinary?
If I'm correct, in his disciplinary, he was still asserting that it qualifies.
Thank you. There was an error in the cash flow forecast that was done that was not picked up by the IDC. Is that correct?
That's correct.
And there was an unauthorized payment for a consultant for facilitation that took place, notwithstanding which there was further approved funding to be given to EML.
Correct.
I'm sorry, just before your next question. Is it accepted that whoever made that payment or made the decision that payment be made, the 1.5, that oh no, I think I may be confusing this. From IDC, you just made payment to the client, and the understanding was that the client knew from what they had been told that IDC is not going to pay this 1.5. Is that right?
Yes, sir, that was a written instruction to the client.
So the actual payment to Memela Trust would have been from the client to Memela Trust.
That's correct, sir.
And not from IDC as a payment to
That's correct,
Memela Trust.
That's correct. It was made by the client.
Okay.
Indeed, but just to follow that up, Chair, that was known to the IDC that payment had been made when it decided to provide further funding.
Yes, Chairperson, this is 2018 now, when it's become known to the IDC.
Thank you. Mr. Manganya, there are certain reporting obligations under the PFMA for the IDC in relation to irregular expenditure and losses resulting from criminal conduct. Are you aware of those provisions?
Yes.
Is it the IDC's intention to report on this aspect insofar as there has been losses incurred by it resultant from this conduct?
Yes, Chairperson, we do report them in our annual report.
Thank you. And going forward, is the IDC intending to put any other measures in place to not permit a repeat of this type of corrupt activity?
Yes, Chairperson, we've certainly learned a lot from this experience. First, in terms of enhancing our due diligence processes, I think with regards to verifying the contract, we could have done more work in that regard. Also, with regards to the review processes on due diligence, I think we need to enhance that process to avoid the reoccurrence of these errors. And we have also looking at all other transactions that were approved involving some of these individuals to identify if there were any other events of this similar nature. And based on those findings, we will enhance our processes around this.
Thank you, Chair. Those are our questions.
Thank you very much, Mr. Manganya. If a need arises for the Commission to ask you to come back, we will ask you. But for now, you are excused. Thank you very much.
Thank you, Chairperson.
Okay.
Indeed, Chair.
Next week it's SABC and
Indeed.
Masan, I think. Yeah.
As I have it, Chair.
Yes. We'll adjourn for the day. We adjourn.